Welcome back to the BlackLetter Podcast. We set out to create an entertaining and exciting podcast about law and business. BlackLetter, the name, comes from the Gothic typeset. Over time, BlackLetter became the only font that English law books were printed in. It made it harder for kind of the common person to understand what the English law books said. BlackLetter came to represent something that was law, that was set in stone, that was sort of old and a well-settled fundamental principle of law. We're here to demystify black-letter law. We're here to demystify things that happen in business and law and where those two meet. And I hope you have fun listening.
And welcome, everyone, to another wonderful episode of the BlackLetter Podcast. With me, I've got Josh Kons, a great friend of mine. He is the principal at the Kons Law Firm. That's K-O-N-S, not C-O-N-S, K-O-N-S. And Josh is a securities litigation attorney. That sounds complicated. And it is a little bit, but we're going to get into what that means. If you have a brokerage account, an investment account, if it's with Schwab, TD Ameritrade, whoever it's with, Josh is there for you if you think that your broker did something wrong or you think something happened that shouldn't have happened. And we're going to talk about what that means and what that is and how Josh got into this. So Josh, thanks for joining us on the BlackLetter Podcast and welcome to the show. I know you've been doing this for about 15 years. It's pretty much your exclusive practice here. So tell me, first, what is securities litigation? I have a brokerage account or investment account, and I'm like, oh crap, I feel like my broker tricked me or did something wrong, or I lost money. I'm really upset. And I call you.
Thanks for having me on. It's exciting to talk about my passion for securities litigation. And I made it. I was a finance major, and then I was a trader after law school. And I kind of fell into the practice area, which was a total niche and kind of still is a niche. But there's really, to answer your question, I mean, there's three types of calls that I get. And there's three different ways to look at securities litigation. And really, it's, let's call it wealth management litigation and then fraud litigation. And those are two different things. Wealth management, there's over 650,000 financial advisors in the United States. And traditionally, it's been a commission-driven, incentive-driven type business. And 99.5% of financial advisors are really good people, but there's that small percentage that like to push high commission products, risky products for their own gain, steal money from clients, divert client funds. So that's kind of the core of what I do. And then around that is securities fraud litigation, where there are a lot of securities frauds out there. I get a call every day from someone that lost their life savings. A lot of them I can't help, but what happens in these cases is the way the state and federal securities laws work is that anyone that's around a securities fraud, whether it's a law firm, an auditing firm, from a broker, they have joint and several liabilities. So you can pursue all these third parties and try and recover. So those are the two buckets that I really see in the securities litigation practice.
So tell me if how are the two buckets differentiated in terms of who the people are that are calling you? Are they the same people? Are they different kinds of people? Like, and does it matter? I mean, are the claims similar? I just, tell me how that works.
Yeah, that's a great question. So there's really two buckets there too. It's really whether or not you had a relationship with a financial advisor that did you wrong or not, right?
Okay.
And if you had a relationship with a financial advisor or investment advisor, typically there's a firm that they're associated with that is usually a FINRA registered firm, which we'll talk about in a second. And that FINRA broker dealer or investment advisory firm has a duty to supervise these financial advisors to make sure that they're doing the right thing.
Okay.
Those claims will typically be arbitrated in FINRA or AAA or other arbitration forums versus litigated. Then the other bucket is really, the fraud bucket, where maybe you got involved in a bad real estate deal and a crowdfunding deal, or maybe you got a call from a guy who posed as a broker who wasn't. Maybe you wake up one day and someone stole money from your Schwab account and Schwab doesn't want to make it right. So those are the two big buckets that we see: broker or advisor driven and client driven.
So the client driven ones, that's more like external fraud, as opposed to the broker ones you're talking about. You're in an unsuitable investment, or they're selling investments to churn and generate fees churning. That's kind of the broker dealer side. The other side is somebody basically stole from you.
Correct. Yes, it's correct. Basically. Yep. Or you picked a, real estate investment on a crowdfunding portal And it turns out that those principals stole the money, and now you want to pursue the portal, the officers, directors, lawyers.
Gotcha.
Yep.
Okay. Well, how did you get into this space, Josh? It's fascinating. I mean, I understand you were a trader, right? You were one of these guys that you sue now. So
I was a guy. I was one of the guys. Yeah, I was a finance major. Before that, I actually worked at a mutual fund company in Milwaukee, Wisconsin, where I'm from. And then I was a finance major, and I ended up being a trader after college. And I realized right away that as much as I like to read and write, I am not strong in math. And so that was just becoming very quantitative. And I was a good writer. So I decided to go to law school thinking I wanted to be a corporate lawyer. And so went to law school, and I clerked at a securities litigation firm in law school. And actually after law school, I said, I'm not much of a litigator. I want to be a corporate lawyer. And I became a corporate lawyer, in-house corporate lawyer, GE. And it wasn't for me. I got to tell you, it was boring. And there's something just exciting about investment in securities litigation. So I fell back into it in about 2010, right after the financial crisis, and kind of rode the wave ever since.
that's fantastic. So you have a good working knowledge. I mean, I suspect most of America has, if not a Charles Schwab account, maybe an Acorns account or a Robinhood account or some kind of, is that what we're calling a securities account? Does it matter what it is? Like the size of the account? Does it matter if it's $100 million or $100,000 or $10,000? What's the difference?
Yeah. Any sort of account with a legitimate registered firm, whether it's a brokerage firm registered and regulated by FINRA, or an SEC registered investment advisory firm, those are kind of the brokered or traditional investment advisory accounts. So that's a lot of people, and it's trillions of dollars. Like I said, over 650,000 financial advisors that are out there helping people. And so you just come up.
So tell me about some of the kinds of claims that things that if I'm somebody with investments and I think they're charging me too much fees, or they made a trade without consulting me, or they put me into like something really risky, and I told them that I'm a 75-year-old retiree who relies on income. Like, what are those claims? What are they called? What do they look like? And what do I do? Do I just call you and you tell me? I mean, I assume that's what I would do.
Yeah, exactly. I mean, so there's really, let's call it, three different types of claims that we see all the time. One is what I'll call an unsuitability type claim or suitability claim, which is kind of related to a breach of fiduciary duty claim. In today's world, these financial advisors do really have a duty to look out for your best interest and make recommendations that are suitable or consistent with your investment profile, right? What we see a lot of is the, like you alluded to earlier, the broker over trading the account or turning the account for commissions, or pushing high risk illiquid products, which are the most commission rich products usually for, to enrich their pocket and at the detriment of the investor. So we see a lot of that. And then what we also see a lot of, and again, this is a very small percentage of all activity that financial advisors engage in, but it does happen where advisors start selling things that might not be approved by the firm, and they're more commission rich, and so they get themselves into frauds. Or what we see a lot of too is firms just pick products to sell that turn out to be a Ponzi scheme or some horrible unsuitable investment. They really should have done more due diligence. We had a big case a couple of years ago against a broker dealer where they were selling a solar company. And one of the questions was, what do you do when you're selling a house on fire? And probably shouldn't have sold that deal, but they did. And all the investors got burned. So those are the types of claims we see in the traditional, FINRA or investment advisory type case.
So what kind of recovery? I mean, this is if we're in a FINRA case in arbitration, are we going to get big recoveries there, or do you just get your money back, or how do you get paid, and how does the person, the consumer, the investor who's harmed, how do they get their money back, and what does that look like?
Yeah, usually we work on a contingency fee if it's a viable case. I mean, sometimes we take it on an hourly basis if it's tough or there's going to be collection issues. But usually, if it's a viable case, we can do it in our contingency. And I'll be honest, I wish I could tell you that everyone becomes whole again, but there's a lot of defenses, there's a lot of paperwork, people sign a lot of documents disclosing the risk. And so back to the suitability case, the other type of case that we see is misrepresentation or fraud case, where a broker says, don't worry, it's safe, and client signs a stack of documents 2 inches thick saying you could lose all your money. This is high risk. So how do you value that case? Usually the recovery is usually 30 to 70 cents on the dollar, sometimes more, sometimes we get, 100 cents, 130 cents, but usually it's a compromise and anything's better than nothing. And when they lost money, any sort of recovery is meaningful for clients.
So this isn't a case where they're going to get some kind of windfall. This is about, for the most part, about recovering what was lost or some quantum, some portion of what was lost. That's
right.
what you do. Okay.
It's sometimes clients get confused because they see personal injury lawyers marketing and in personal injury or those types of litigation and practice, your medical bills get paid, the hospital bills are paid, you get a check for 20 grand and the attorney gets paid. So the clients kind of feel whole through their process. This is not that process. I wish it was, but this is about loss mitigation versus complete recovery. Like I said, sometimes we can do it, but there's always defenses and there's always issues. So
what makes FINRA litigation or FINRA arbitration different than other types of litigation or arbitration, such that somebody needs an expert like you, a former trader, somebody who was in the space? I mean, obviously that experience helps, but what makes it different than what a regular lawyer would do?
So FINRA is, the SEC regulates all these brokers and dealers and investment advisors, but they delegate their authority to FINRA, which stands for the Financial Industry Regulatory Authority, which is called a self-regulatory organization, which kind of supervises all of these brokers. And as part of that, they make all the brokerage firms and all the brokers put arbitration clauses in every agreement you sign that says you'll adjudicate your dispute in FINRA's captive arbitration forum. But it's actually okay for investors. It's not bad. It's fast. It's private. 90% of cases do settle. It's a lot less document intensive. And so that's why you need an expert in the FINRA forum to really make sure that you understand the claims and defenses. You understand where to look for. These brokerage firms are highly regulated and they know where to hide the dirty documents, so to speak. So you have to understand the claims, the defenses, where to look and how to value them and how to settle them.
Is that FINRA clause something that's required by law in all broker-dealer agreements?
Correct, by law. And then the investment advisors on that side, they kind of adopt the same model where there's arbitration clauses in almost every investment advisory contract. So it's very rare that you'll actually see a dispute against a brokerage firm or an investment advisory firm see the light of day in court.
So what's the difference between a FINRA clause in an investment agreement and the investment advisory agreement? What's the difference between those two contracts?
So really, the broker dealers have to use FINRA as their arbitration forum.
Okay.
Investment advisors don't. A lot of times they do use FINRA too, but sometimes it's other arbitration forums like the American Arbitration Association or another organization called JAMS.
So if you have advice for either lawyers who have a client with this problem or clients who think they have this problem or think they have an issue with an investment they made, what's the best advice you can give them?
Yeah, the best advice for clients is, look, you got to keep an eye on your broker. You got to get second opinions, just like you would with a doctor or a lawyer. Just make sure you're watching what they're doing, reading the statement. When they say things, kind of understand that maybe there's a disconnect. When they say, hey, let's trade options, it's a good idea. And you've never traded options, maybe that's not a good idea then. And for lawyers, really, getting the claim referred out to a good, expert in securities litigation or arbitration is the key, because the lawyers that dabble in this practice area get chewed up. It's very hard, very technical. But the last thing I'll say is everyone needs to act fast. The statute of limitations are really short in these cases. That's probably the number one defense we see, and it's very tough. And clients, if they suspect something's wrong or they think, well, got to jump on it as soon as possible.
It's strict. So I will just close with this, Josh. So I will testify, audience, listeners, for Josh. He handled a case that my firm sent to him that we co-counseled with him on, but Josh did the case. And the client had invested millions of dollars along with a number of other clients. They'd each invested a few million, every single one of them. And the investment advisor top 5 in the country. Like he made this, and he was at a big firm, and he literally had spent all the money and was creating fake reports for 7 or 8 years and sending these investment returns to all of these very wealthy, sophisticated, I would say, Josh, very sophisticated individuals. Some people who had done tax law for 20 years had invested in this, and other people had massive investments, had invested with this guy. And he had literally just lost all the money or spent it. Weird circumstance. Josh recovered everything for a number of reasons, partly because the guy ended up killing himself and with an insurance policy, but you did get some money out of the broker dealer, I believe.
That was a good case, good result. It was really unfortunate that the way it ended with ending his life, but that insurance recovery did help the clients, and then the investment advisory firm, which was a very large, reputable firm,
one of the biggest.
Yeah, they also did right by these clients too. So it was a good result on that one.
And I think to me, it was so interesting that such a big firm and a guy who's ranked like top 5 investment advisors in the country, this could happen. And that terrifies me every day. And yet I still have a brokerage account, but I like to see my stuff online. That's my like little personal check, is if I can log in and see it, and I don't need to get an email with an Excel spreadsheet from somebody, for a little bit better. That's my 10 cents.
That's it. That's right.
So, well, Josh, I really appreciate your time. Awesome.
Thanks for having me. I appreciate it.
Hey, if people want to find you, what's your website? What's the best way to reach you?
Best way to reach me is my website is investmentfraudattorneys.com. And I can be reached at 860-920-5181. If you ever see a case, securities litigation, any sort of securities fraud, free consultations, I'll take a look. Hopefully I can help. If not, at least, you got a good evaluation of where you stand and what your rights are.
And thank you, everybody in our audience, for joining me and Josh Kons. So I appreciate your time for listening. Download us wherever you get your podcasts. We'll see you next time on the BlackLetter Podcast.